My wife secretly agreed to carry her boss's baby for $45,000. After 8 months of lies, she told me to rethink what being a husband means. She even texted her sister that I would never divorce her. What she didn't know was that I had a recorder in my pocket and 47 pages of her hidden emails. When my lawyer dropped them on the judge's desk, the courtroom went silent. My name is Grant. I'm 38 years old, and until about 2 years ago, I would have described my life as genuinely good. Melissa and I met in our late 20s through mutual friends. Nothing dramatic, nothing cinematic. She was sharp, easy to talk to, the kind of person who remembered small details about people and made them feel like they mattered. I liked that about her. I still do, in the way you can still appreciate something that burned you. We got married young enough to be optimistic and old enough to know better, bought a house in a suburb where we knew our neighbors' first names, and had 3 kids in 6 years. A boy, then 2 girls. The youngest had just turned 4 when everything fell apart. We weren't wealthy. We were comfortable in the way that means you're 1 bad month away from uncomfortable. I worked in logistics management. Melissa had bounced through a few administrative roles before landing a position as executive assistant at a firm run by a man named Richard Whitmore. The pay was better than her previous job by about 40%, and I was genuinely glad for it. We had a mortgage, a daycare bill, and a car that needed work every 8 months whether we liked it or not. The extra income mattered. What I didn't fully account for was how much that job would matter to Melissa in ways that had nothing to do with money. Whitmore was the kind of employer who made people feel chosen. He remembered birthdays. He praised work specifically, not generically. When Melissa did something well, he told her exactly what she'd done and why it was valuable. She started mentioning him at dinner, not obsessively, just consistently. Richard thought the proposal was excellent. Richard said I handled that client better than anyone he'd worked with. I noted it. I didn't flag it. I assumed it was the normal glow of being good at your job and being recognized for it. Then, sometime in the 2nd year, the tone shifted slightly. Whitmore and his wife had been dealing with fertility issues. This became known in the office, the way personal things always become known in small professional environments. Melissa came home one evening and told me about it quietly, like she was carrying it herself. I remember thinking she seemed more affected than I expected. I told her it was sad. She nodded and didn't say much else. I didn't connect it to anything at the time. That was my mistake. About 8 months later, she came home with a particular look on her face, the slightly rehearsed quality she always had when she was expecting pushback. She sat down across from me at the kitchen table and said she wanted to talk about something important. She called it a beautiful gift. The kitchen table was the same one we'd eaten breakfast at every morning for 6 years. The kids' drawings were still on the fridge behind her. I remember noticing that the gap between how ordinary the room looked and how not ordinary the conversation was about to be. Melissa laid it out calmly. Richard Whitmore and his wife had been struggling with infertility for years. They had found an egg donor. They had a legal framework in place. What they needed was a gestational carrier, someone to carry the embryo to term. And Melissa wanted to be that person. She used the words beautiful gift within the first minute. She said it like she'd been practicing it, because she probably had. I asked her to slow down. I asked her when she had started thinking about this. She said a few weeks. I asked her if she'd talked to anyone else about it. She paused just long enough before answering, and then said she had mentioned it to Richard, that she was seriously considering it. Not that we were discussing it, not that she was waiting for my input. She had already told her employer she was in. I looked at her for a moment. Then I asked the question that mattered. If I said no, would she still do it? She said she hoped it wouldn't come to that. I pressed. I needed a direct answer, not a pivot. She said, "At the end of the day, Grant, it's my body." I sat with that for a second. Then I told her clearly, no raised voice. No theatrics, that if she moved forward with this without my agreement, I would file for divorce and I would seek full custody of our 3 children. I wanted her to hear it as a fact, not a threat. She looked at me the way people look at someone who's overreacting. "You're being dramatic," she said. "This is a good thing. Why can't you just be supportive?" I didn't argue. I got up, walked to the bedroom, and sat on the edge of the bed for a long time. I had told her exactly where the line was. The only question now was whether she believed me. 3 days later, she asked me to be more open-minded. I already had a recorder in my pocket. The next 2 weeks had a particular quality to them. Not loud, not explosive, just the slow accumulation of small moments that each meant something on their own and something much larger when you lined them up together. The first one happened about 4 days after the kitchen conversation. Melissa came home with a manila envelope and set it on the counter the way you'd set down mail casually, like it was utility paperwork. I picked it up. It was a packet from Whitmore's attorney. Medical protocols, a proposed timeline, liability terms, and a compensation figure, $45,000. I stood there and read it twice. Not because the number shocked me, but because of what the number implied. Documents this detailed, this organized, this far along in legal drafting, this wasn't a few weeks of consideration. Someone had been working on this for a long time. I looked at Melissa and asked her again when this had started. She said it didn't matter when it started. What mattered was that she wanted to do it. I put the packet back on the counter and didn't say anything else that night. The second moment happened a few days later. Melissa's sister Clara came over, and I was in the next room while they talked in the kitchen. I wasn't trying to listen, but the house is small, and Clara's voice carries. I heard her ask, "Are you sure Grant is okay with this?" Melissa said, "He will be." Not he is. Not we talked and he came around. He will be. Present tense conviction about a future that hadn't happened yet. Like my position on the matter was a temporary inconvenience she intended to wait out. I stood in the hallway and let that land. The third moment was the one that closed the door for me. About a week after the packet arrived, Melissa asked if we could talk again. She framed it as a chance for me to share my concerns. I sat down at the kitchen table. I had the recorder running before she came in. I'd bought it the week before because I had already understood, somewhere underneath everything, that words were going to matter later. The conversation covered familiar ground. She said she had emotionally committed to this. She said the Whitmores were counting on her. She used the phrase noble sacrifice twice without any apparent awareness of how it sounded. And at one point she said that if I couldn't support something this meaningful to her, I needed to rethink what being a husband means. I let that sit for a second. Then I told her same as before, same tone, same words, that if she signed that agreement, I would file for divorce and I would take the children. I wasn't negotiating. I wasn't asking her to feel sorry for me. I was telling her what was going to happen. She shook her head slowly, like I was a problem she'd almost solved. "You won't," she said. "You need me too much." That night, I opened my laptop and created a folder on the desktop. I labeled it with the date. I saved the recording into it. Then I went to bed. The next morning, she was already on the phone with Whitmore's attorney. After that recorded conversation, something shifted between us. Not loudly. The house still functioned. We still fed the kids, managed the schedule, said good morning. But there was a new quality to the silence, the kind that exists between two people who have both said what they mean and are now just waiting to see who moves first. I noticed things in that waiting period. Melissa's phone face down on the counter more often than usual. A second email account she'd started using I only knew because a notification flashed across her screen when I walked past. Whitmore's name in her call log when she left her phone unlocked on the kitchen table. None of it was dramatic. All of it was deliberate. She was managing this the way you manage a business transaction, keeping the relevant parties informed, keeping the irrelevant ones at a comfortable distance. I had become the irrelevant one. Melissa moved first. 2 days after our last conversation, I came home to find her in the kitchen with a FedEx envelope on the counter. She had her hand resting on top of it, which told me she had been waiting and that she had rehearsed this part. She said she had something to tell me. Then she said she had signed the surrogacy agreement. Not "I need to talk to you about something." Not "I've been thinking." She said it the way you'd mentioned that you'd renewed your car registration. A completed task, delivered for information purposes only. I asked her when she had signed it. She said that morning, at Whitmore's attorney's office. I asked her if she had considered anything I'd said over the past 2 weeks. She said she had considered it carefully, and that she believed this was right for her, and that she hoped I would come around once the process was underway. She used the phrase noble sacrifice again the third time she'd said it, and each time it sounded a little more like a shield and a little less like a conviction. And then she said some things are bigger than one person's discomfort. I looked at her for a moment. "You just blew up our family." She shook her head slowly. "I'm doing something meaningful, Grant. You're the one making it a problem." I didn't argue. I walked to the home office and opened my laptop. I had the name of a family law attorney a colleague had mentioned months back, not because I'd been planning for this, but because I write things down. I drafted a short email, 4 sentences. I outlined the situation and asked for availability. Then I opened the folder on my desktop, the one labeled with the date, and started printing. She appeared in the doorway about 20 minutes later. The printer was still running. She looked at the stack of pages, then at me. I didn't look up. I think that was the first moment she understood that my silence was not the same as surrender. She had called my ultimatum a bluff. She had told her sister I wouldn't follow through. She had signed a legal agreement with her employer on the assumption that I needed her more than I needed to keep my word. She was wrong on all 3 counts. My appointment with the attorney was the following Monday. By then, I had already printed 47 pages. My attorney's name was Joanna Voss. She had been practicing family law for over 20 years, and she had the particular quality of someone who has heard everything and is therefore surprised by nothing. I sat across from her desk on a Monday morning with a printed folder and walked her through the timeline. She listened without interrupting. When I finished, she asked me 3 questions. Then she picked up a legal pad and wrote 3 words. Explicit. Repeated. Documented. She underlined all 3. She told me the recording alone was significant not because it proved anything about the surrogacy, but because it established a clear pattern. I had communicated my position directly, more than once, with specific consequences attached. Melissa had acknowledged it and proceeded anyway. That was the foundation. What we needed to build on top of it was the full picture of how long this had been in motion without my knowledge. That's where the email chain came in. During the disclosure process, Melissa was required to provide records of all communications relevant to the surrogacy arrangement. Whitmore's legal team produced their side of the correspondence as well. My attorney laid the printed chain on her desk and pointed to the first email. It was dated March 14th, sent from Whitmore's attorney's office to Melissa's personal email account. Subject line: Potential arrangement initial discussion. The kitchen conversation, the one where Melissa told me she'd been thinking about this for a few weeks, had happened in November. March to November is 8 months. I sat with that for a moment. Not with anger, exactly. More with the specific clarity that comes when a thing you suspected becomes a thing you can prove. For 8 months, Melissa had been in contact with Whitmore's legal team about carrying his child. For 8 months, not one email, not one exchange in that entire chain contained my name. Not a reference to my opinion, not a mention of whether I had been told. The emails treated me the way you treat a piece of furniture, not maliciously, just completely without consideration. I was not a variable in their planning. My attorney flagged the chain as Exhibit B. The recording was Exhibit A. Then came the texts. Clara, Melissa's sister, was subpoenaed for her phone records after my attorney identified her as a primary recipient in Melissa's communications during the relevant period. Clara cooperated. I don't think she did it to hurt Melissa. I think she answered honestly because she didn't see another option, and because some part of her knew what the text said. 2 messages in particular. The first was dated 2 weeks before Melissa signed the agreement. Melissa wrote to Clara, "Grant is against it, but honestly this is my right and I'm not going to let him take that from me." The second came 4 days later. "He keeps saying he'll divorce me, but he won't. He needs me." I read those texts for the first time sitting in Joanna's office. I didn't say anything for a moment. What struck me wasn't the anger, it was the word won't. Not I hope he won't, not I don't think he will. Just won't, stated as fact. She had looked at 9 years of marriage, at 3 children, at every conversation we had ever had, and concluded that I was not a person who would hold the line. That recalibration understanding that she had never actually believed me changed how I thought about the hearing. She wasn't going to arrive in that courtroom expecting a fight. She was going to arrive expecting the Grant she thought she knew. There was one more document. The surrogacy contract itself contained a clause that Whitmore's attorney had inserted as standard legal protection, a waiver, stating that Melissa acknowledged her participation was voluntary and that no claims of undue burden to her existing family structure would be made against the Whitmore family. In other words, Whitmore's own legal team had anticipated that a spouse's objection was foreseeable and had protected their client accordingly. My attorney read that clause twice. Then she looked up and said, "They knew." I nodded. I already knew they knew. Joanna added the contract to the folder. Exhibit A, the recording. Exhibit B, the 8-month email chain. Exhibit C, the text to Clara. Exhibit D, the contract with its waiver clause. Our court date was set for the 3rd week of September. I was ready. Melissa thought she was too. The 6 months between filing and the hearing had their own rhythm. Not easy, but manageable, which is about the best you can say for that kind of period. Melissa moved out 2 months after I filed, at her attorney's recommendation. The kids stayed with me. We told them together, sitting at the kitchen table, that mom and dad were going to live separately for a while. The youngest asked if that meant forever. I told her I didn't know yet, but that wherever things landed, she was going to be okay. I don't make promises I can't keep. She accepted that better than I expected. Kids are more adaptable than we give them credit for, and more perceptive. They had felt the tension in the house for months before we named it. I kept the routine tight. School drop-offs, pediatric appointments, daycare pickup, dinner at the same time every evening. Not because I was performing stability for a future judge, although I understood that it would matter, but because 3 kids needed a functioning household and I was the one running it. I had the school records, the medical logs, the pickup history going back 4 years. Joanna flagged all of it. Documentable primary caretaking, she called it. I called it Tuesday. There were risks, and I was clear-eyed about them. The first was optics. Melissa was pregnant visibly, physically carrying a child, and a courtroom is still a room full of human beings. I knew how that image read. A pregnant woman being divorced by her husband had a particular emotional gravity, regardless of the circumstances. Joanna addressed it directly. The pregnancy itself was not the issue before the court, she said. The documented pattern of exclusion and deliberate misrepresentation was. We weren't asking the judge to penalize Melissa for her body. We were asking her to read 8 months of emails and 2 texts and 1 recorded conversation and draw her own conclusions. The second risk was resources. The Whitmores were wealthy enough to retain excellent legal representation, and while they were not technically a party to the divorce, Whitmore's attorney sent a letter to the court suggesting that Melissa's significant emotional contribution to the Whitmore family deserved weight in any stability analysis. Joanna filed a response the same week. She told me later it had been, in her words, efficient. I didn't ask her to elaborate. The third risk was the one I thought about most. In cases involving minor children, judges weigh the primary caretaker history heavily. I had that history. But I also had 3 kids who loved their mother, which meant whatever the judge decided, someone was going to lose something. I understood that. I just needed to make sure the person making the decision had the full picture. The night before the hearing, I sat at the kitchen table after the kids were in bed. The same table. I had my coffee and the folder and the particular quiet of a house where everyone else is asleep. My youngest had asked me that evening if mom was coming back. I told her the truth I didn't know yet, but we would be okay either way. She nodded and went back to her drawing. I sat there for a long time. The next morning, I put on a suit, dropped the kids at my sister's, and drove to the courthouse. Melissa was already in the lobby when I arrived, standing with her attorney. She looked composed, prepared. She had the particular expression of someone who believes the room is already on their side. I held the door and walked past her without a word. The courtroom was smaller than I expected. Fluorescent lights. The same recycled air I'd noticed the first time I walked in for a preliminary hearing, carpet that hadn't been replaced in years. Melissa sat at the table on the left with her attorney. I sat on the right with Joanna. The judge, a woman in her mid-50s named the Honorable Patricia Sloan, was already reading when we were called to order. She didn't look up immediately. She finished the page she was on, set it down, and then looked at the room with the specific patience of someone who has never needed to perform it. Melissa's attorney opened first. He was polished and methodical, and he had clearly built his case around a single framing. Grant as a controlling husband who had issued ultimatums to punish his wife for exercising her autonomy. He used the word controlling 4 times in the first 6 minutes. He used the phrase emotional coercion twice. He painted Melissa as a compassionate woman who had made a deeply personal decision about her own body, and painted my objections as a pattern of domination dressed up as concern. It was a well-constructed argument. I watched the judge's face while he made it. She listened without expression, which told me nothing and everything. Then Joanna stood up. She didn't argue with his framing. She didn't call it inaccurate or unfair. She simply said she'd like to introduce the evidence, and she started with the recording. The courtroom heard my voice first. Calm, specific, unhurried. If you carry this baby, I will file for divorce, and I will take the children. Then Melissa's, faster, slightly impatient, the tone of someone who considers the conversation already resolved. You might need to rethink what being a husband means. Judge Sloan set her pen down. Nobody in that room said anything for about 4 seconds. I counted. Joanna moved to Exhibit B without pausing. She handed the email chain to the clerk, who passed it to the judge. Joanna stated the relevant facts aloud as the judge read. First contact from Whitmore's attorney to Melissa's personal email, dated March 14th. The kitchen conversation in which Melissa told her husband she had been thinking about this for a few weeks dated November. 8 months of correspondence in which Grant Calloway's name did not appear once. Melissa's attorney objected on relevance. Judge Sloan overruled without elaboration. She kept reading. Then Joanna introduced the texts. She read them into the record herself, in the same even tone she used for everything. First message, 2 weeks before signing. Grant is against it, but honestly, this is my right, and I'm not going to let him take that from me. Second message, 4 days later. He keeps saying he'll divorce me, but he won't. He needs me. The courtroom had a particular quality of silence after that. Not uncomfortable exactly, more like the silence of a room where something has just become undeniable. I looked at Melissa. She was very still. Her expression had shifted not to guilt, not yet, but to the specific look of a person whose private self has just become fully public. The version of herself she had shown her sister, the version that had dismissed me as a manageable inconvenience, was now in the court record. Joanna wasn't finished. She introduced Whitmore's letter, the one suggesting Melissa's significant emotional contribution deserved weight in the stability analysis. She read the relevant line aloud. Then she noted, calmly, that this letter had been submitted by the same employer who had been in private contact with the defendant for 8 months, prior to her husband's knowledge, and whose own legal team had inserted a waiver clause into the surrogacy agreement specifically to insulate the Whitmore family from any claims arising from existing family objections. She placed the contract on the clerk's desk, open to the relevant clause. Judge Sloan looked at that clause for a long moment. Then she nodded, almost to herself. She turned to Melissa directly. She asked one question. At the time you signed the surrogacy agreement, had your husband communicated to you, clearly, that he considered this a condition for the continuation of the marriage? Melissa's attorney started to respond. The judge held up one hand and repeated the question to Melissa. Melissa said, he expressed concerns. Joanna placed the recording transcript on the clerk's desk without a word. Melissa looked at it. Then she said, quietly, I believed he would come around. Judge Sloan didn't raise her voice. She didn't editorialize. She stated, clearly and without drama, that the court's primary obligation was the welfare and stability of the 3 minor children. She noted the documented primary caretaking records spanning 4 years. She noted the 8-month period of deliberate omission. She noted that the question before the court was not whether Melissa Calloway had the right to make decisions about her body. She did, unambiguously, but whether the pattern of exclusion and deliberate misrepresentation reflected the judgment and transparency expected of a custodial parent. She granted me primary physical custody. Melissa received scheduled visitation. I kept my eyes on the table in front of me. I didn't look at Melissa. I didn't need to. Joanna put her hand briefly on my forearm and said, that's it. That was it. Whitmore's letter was still sitting in the evidentiary pile when we filed out. Melissa stayed seated. I walked past her without stopping. She had called it a beautiful gift. I got my kids. That was 6 months ago. I won't tell you the adjustment was easy, because it wasn't. The kids had hard weeks. The youngest still asks for Melissa at unpredictable moments at dinner, in the car, sometimes right before bed. I answer honestly every time. I don't editorialize. I don't tell them what to feel about their mother. That's not my job. My job is to make sure the lights are on, and the lunches are made, and someone is there when they wake up from a bad dream. Melissa keeps her visitation schedule inconsistently. She shows up for about 2/3 of her scheduled days. I document every absence. Not to use it against her, the case is closed, but because I write things down. It's just who I am. The Whitmores had a healthy baby. A boy, I heard. Melissa was there for the birth, as planned. There was a card afterward, and a cash gift, and what I'm told was a genuinely warm expression of gratitude. And then, over the following weeks, the contact tapered off. The messages got shorter, the invitations stopped coming. The relationship that had felt, to Melissa, like something permanent and meaningful, the sense that she had become part of something larger than her own life, quietly returned to what it had always been. An employment arrangement. A transaction that had concluded. I don't say that with satisfaction. I say it because it's what happened. Clara reached out about 2 months after the hearing. She said she was sorry. She said she hadn't understood how deliberate it had been. I thanked her for cooperating with the subpoena. I told her none of it was her fault. I meant it. I think Melissa genuinely believed she was doing something good. I also think she genuinely believed I wouldn't hold the line. Both of those things can be true at the same time. People are complicated. Marriages are complicated. What isn't complicated is what you owe the people who depend on you. This morning I made 3 lunches, checked 2 backpacks, and listened to my youngest argue that cereal without marshmallows isn't real cereal. The 3 of them sat at the kitchen table, the same table bowls in front of them, backpacks by the door, the ordinary noise of a morning that belongs to us. I'm aware of that table. I don't need to explain why. If you're in a situation where someone keeps reframing your limits as your problem, document everything. Not to win an argument, to know the truth yourself. I didn't need to rethink what being a husband means. I already knew.